Good afternoon, everybody. Thanks for joining me today. My name is Darren Sall. I am your employment lawyer for the next 30 minutes. I practice in both employment and personal injury and long-term disability in BC and Alberta. I'm an associate with Samfiru Tumarkin in Vancouver is where I'm based out of, but I do practice in BC and Alberta. And I'm here to answer all your questions for the next 30 minutes. So please don't be shy, jump in, take advantage of this. I would say there are no questions too small. There might be a couple questions that are too big, and I'll do my best to answer those on the air, but we may need to connect off air. And throughout the show, there'll be various contacts with contact links that'll show up in the bottom left-hand corner of the screen. Phone numbers. You can email us at help@employmentlawyer.ca. You can go to employmentlawyer.ca, our website, just popped up in the bottom there, I believe, which will have all of our contact details. You can get in touch with any one of my colleagues, our associates in any one of our offices in Ontario, BC, or Alberta, at any time. You can also touch base with our wonderful intake team to direct you to the appropriate person or to give a bit of information on your matter, and so we can connect you with someone to give you some help. While we wait for some questions to come in, I've got one. It's from Teresa off YouTube. Teresa, good afternoon to you as well. If you have a question, feel free, pop it in, and I'm happy to answer any questions you guys have. That's the purpose for today. Well, I've got a couple topics I'd like to talk about when we get a little bit of downtime here. If we do, questions seem to be coming in already. One thing I will touch on is, recently, especially in the tech industry, I'd say over the last 6 to 8 months, even over the last year, there's been a swath of mass terminations, just group layoffs from companies, and there's important rights for everyone to know in case this happens to them or happens to a friend or a colleague or a family member of yours. If they are part of what's called the group termination situation, which is typically where groups of people are being terminated, and there are additional rights. For example, in British Columbia, if you have over 100 people or over 200 or 400 or 500 people, there's varying tiers to look at who are terminated from a single location of an office or a company within a certain time period. It's 2 months in BC, changes in Alberta, changes in Ontario. You are entitled to what I just call enhanced notice. It is additional notice of termination in addition to your standard Employment Standards Act or Employment Standards Code in Alberta rights, and whatever common law rights you're owed, or contractual rights that you may be owed under any employment contract you may be subject to. So the key there is, if you're in a situation where you're not just being terminated yourself, where you have a number of people who are being terminated, you may be entitled to enhanced rights or additional notice or severance. If you're in a situation like that, please call us. They're very fact specific, and it's always good to get in touch with us. Our consultations are free. We're happy just to have a chat. And at the end of the day, even if we can't assist you, you're at least in a situation where you aren't going forward, wondering, what if I called, what would have happened then? And so I'll talk a bit more about what those rights look like shortly. We have a question that came through from JT through Reddit, it looks like, or through YouTube. And so JT asks, I signed an offer letter for hourly pay and was putting in over 50 plus hours weekly. A month later, my rate of pay was changed to salary. What can I do? So, JT, it's an interesting question. I mean, a lot of this will depend on, I think, what kind of work you're doing. Generally, here's my assumption. My assumption based on what you've written here is that obviously the salary is going to be calculated on your hourly rate based on a 40-hour work week. The fact that you were putting in 50 plus hours, obviously the company was probably paying you overtime for that. I hope they were. They should have been. And you were costing too much money. The company at that point can renegotiate with you. What they can't do is what they appear to have done here, which is unilaterally change the terms of your employment. This could be a constructive dismissal. And it seems to me like it would be if you're making 20 extra hours, 10 or 20 extra hours a week. you're working over 50 hours. Yeah, I mean that's a lot. If that's consistent, that comes to a very high amount that you're being deprived of. And so I would say the first thing to do in a situation like this, where your employer unilaterally changes something with your employment, is to lodge an objection in writing. And the simplest way to do that is simply say, I don't agree to X change, whatever change was made. Send that to your employer. Lodge something in writing. Always, the old adage, if it's not in writing, it never happened, is very true when it comes to things like this. Do not rely on verbal representations. You want everything to be in writing, emails, letters, or whatnot. And on that note, if you do have it's a bit of a tangent here, if you do have a situation where you've been informed of something verbally, or the company refuses to put something in writing to you, what I've suggested to people in the past is to put it in writing yourself. Email the responsible party and say, I confirm that on this day at this time, or at this day, you informed me of these changes to my employment. You informed me that my employment would be changing in this way. I'd be given these responsibilities additionally, or these responsibilities would be taken away from me, or my title was going to change, whatever the change is. Put that in writing to the other party and just say, if I have this mistaken, please let me know. While it's not perfect, it does show, if you have to go and argue this later, it does show the court that you provided the company with an opportunity to correct any misapprehensions you might have had. Because if you're claiming a constructive dismissal, like JT may be looking to do, a hallmark of that a lot of people don't realize is what you're doing is you're resigning from your position based on the employer's evidenced, the fact that your employer has evidenced their unwillingness to be bound by your employment contract any longer. And by doing that, they've terminated your employment. But the hallmark of a constructive dismissal is that based on their actions, you're resigning from your employment as you view your employment as being terminated. If a constructive dismissal is not successful, then it turns out you would have just resigned from your position. So again, before making any, big statements to your employer, aside from, lodging a simple objection, doesn't have to be anything complicated, just a 1 or 2 liner, you've changed my position as of this date, or you've told me you're going to be changing my position. I object to this. I do not agree to this change. Send that in writing, contact us right after. And these are all very, very fact-specific scenarios. A constructive dismissal is always a very fact-specific scenario. There is no one-size-fits-all to that. And so please do contact us, contact an employment lawyer. And if it's not us, we're happy to speak to you. We have free consultations, but do contact an employment lawyer to get a better assessment of what your rights may be in your specific situation, or how best to handle it. So JT, with that more information, I hope that kind of gives you a sense of what you can do right now, which would be to maybe lodge an objection, and then give us a call. If you're in BC or Alberta, you can look me up on the website. I'm happy to speak to you myself, and to give you a better assessment, a more tailored assessment of your rights, and what may be the best way for you to approach this formally with your employer. I think we have a little QR code or whatnot on the bottom right of the screen there, and so feel free to whip your phone out and grab my information and reach out to me directly. I'm happy to make some time and speak to anybody offline as well. And this goes for people who want to ask questions but are maybe too shy, or maybe there's personal information involved that you don't want to put on the air. Completely understand. Again, contact me, contact one of my colleagues. We're happy to speak to you in confidence about your situation. So JT, I hope that answers your question. And we'll move on to C. C off YouTube asks, if an employee's workplace accommodation, ADHD, has been revoked without the employee's knowledge or consent, and without any explanation or reasoning, is the employer in the wrong? And so, see, if you require accommodation for what I assume is your diagnosed condition of ADHD, I'm not quite sure what you mean by it's been revoked. If the employer has refused to put it in place, or if the employer has perhaps been accommodating you and pulled it away, it's really the same outcome. what the analysis looks at is whether or not the proposed accommodation would be an undue hardship on the employer to impose. Now, it's a very, very high bar to meet, as it should be. And a lot of the times where an employer says, oh, this will be an undue hardship, I found, at least personally, that a lot of the claims where I've seen that, it's not an undue hardship. It's simply an inconvenience for the employer, or it's something the employer doesn't want to do. Unfortunately, that's not, the employer's call in that case. You are entitled to an explanation or reasoning, especially if your accommodation, the lack of that is now resulting in you being unable to do your job. Maybe performance issues are starting to creep up or whatnot, or they're going to use this as a prelude to terminate you. If that is the case, your employer may be guilty of a human rights violation. And in which you're entitled to compensation. Now, a common misconception is that you have to wait to be terminated to file a complaint on this basis, and that is not true. If you are being, for example, discriminated against in the workplace, if the removal of an accommodation has resulted in your inability to work, then that is something that we could potentially pursue. Again, these are with a lot of these situations, and this is no exception. Unfortunately, it is a very tailored response that we would have to give, knowing a lot more about the circumstances, type of work, job duties, what the accommodation is, why the employer says they can't accommodate that, and a lot of the, to be clear, a lot of the people I've talked to, sometimes their employers just don't know that they're required to do this, and sometimes they just don't care. That is thankfully few and far between, but where that does show up, then you would have an arguable, definitely a case for human rights violation, which could entitle you to damages. If you lose your employment because of this, they say, well, for example, maybe C needs mini breaks. Maybe you need a mini break every 45 minutes to walk around for 5 minutes, and that's it. And the employer says, well, no, I'm not going to allow you to do that. In my view, that's completely unreasonable. And in that case, if they terminate you because of that, you'd have a claim for both wrongful dismissal as well as a human rights violation. And I think, I saw something. So you see, has added on to say, if an employer threatens to put an employee on an involuntary medical leave after they have had to miss work due to severe PTSD symptoms, and then due to COVID-19, are they allowed? So just give me a second here to work this through in my head. The employer threatens to put an employee on involuntary medical leave after they have had to miss work due to severe PTSD symptoms and then due to COVID-19. Are they allowed? So general proposition, employers cannot place you on an involuntary leave of absence. Disciplinary leaves or administrative leaves or things like that are required to be paid. A leave of absence is something that should be, especially a medical one, should be supported by your doctor and should be requested by the employee. If your doctor thinks you are required to be on medical leave, short-term disability even, or long-term disability, you usually need a doctor's recommendation or doctor support for that. The employer simply putting you off, and I'm assuming an involuntary medical leave would be unpaid. If it is unpaid, then you would have a claim for constructive dismissal of employment at that point, as well as potentially a human rights violation and additional damages flowing from that. So it seems like there's a bit of backstory here, and there's a bit of complications with your situation. And I think if none of this has come to eventuate yet, I would recommend reaching out. Happy to speak to you, me or any of my colleagues. And if it has already happened, again, still reach out. I think there's probably something we can do for you here to help you either navigate this to a better outcome, or to hopefully solve this issue. Now, here is where the caveat's going to come in with things like involuntary leaves due to COVID-19. If you're in BC, for example, so I'm only going to speak about BC at this point, there has been a case that was released. It's called the Parmar decision, and essentially what the decision, the crux of it basically says, an employer is permitted to place you on an unpaid leave of absence in response to a mandatory vaccination policy. Now, most of these cases have already been dealt with, because the mandatory vaccination policies were a creature of, 2020, 2021. If your employer is placing a mandatory vaccination policy in place now and trying to put you on an unpaid leave, and again, see, I don't know if that's kind of what the timeline you're talking about here is, contact us, because I think that would change the analysis in my view. But from a base position, something for everyone to be aware of is that your employer cannot place you on an unpaid leave of absence. Doing so, any kind of layoff, anything like that, unless you agreed to things like a layoff in your contract, or you agree to the layoff when they ask you to make it, you can claim a constructive dismissal. That can ground a claim for a constructive dismissal. And in each of the provinces, there are terms under which you can only be on a temporary layoff for a certain period of time. Once you exceed, we call it the statutory limit, the law determines your employment as terminated by operation of law. For example, in BC, it's 13 out of 20 consecutive weeks. And so once you break that 13-week mark, you can claim your employment as being terminated, and then wrongful dismissal damage is attached to that. Severance attaches to that. Okay, so I'm going to back up a bit here. We have some other questions that have come in. Let's see. Stephen. So Stephen Bilks of YouTube asked, what happens if your doctor wants you to take more time off than your employer provides? Is your leave still protected, or can they let you go? So here's the thing, Stephen, is that an employer can let you go at any time. If, for example, your doctor is saying you need 8 weeks off, and your employer says, I'm only going to give you 4, and then they terminate you, that would be not only a wrongful dismissal, they would owe you, it'd be an illegal termination. They would owe you wrongful dismissal damages, and what the content of those would depend on any employment contract that you were subject to, as well as the common law. And if that does happen, where they terminate you and your doctor's supporting the fact that you should be off, then you've got a discrimination claim based on physical or psychological or mental disability, depending on why you need the medical leave. Like I said, this kind of ties in to C's question a bit, where the employer is required to accommodate you to a reasonable level. And if your medical practitioners are saying that you need a certain amount of time off, then on stress leave or something like that, as long as it's medically documented, your employer has an obligation to kind of adhere to that or abide by that. And if they do terminate you while on a medical leave, or while they're aware that you require some kind of medical leave, and that's the reason they're terminating you, that's a very important part of this. Is that has to be the reason they're terminating. For example, if your employer comes to you and says, listen, Stephen, we're going to terminate you on Friday. It's your last day. And then you come with a note on Thursday that says, oh, I need stress leave now. I mean, that's going to be a very different situation. Arguably, there's no discrimination there, as long as your employer didn't know that you required stress leave prior to making that decision to terminate you. But again, it's very fact specific. I think in your situation, Stephen, is if you've notified them that you need, a medical leave for X number of weeks or days, and they say, well, we're only willing to give you this, then, the other option is that they keep you on an unpaid leave. Right? They would say, okay, well, maybe we'll give you sick days up until halfway through, and we'll let you use your vacation days for the rest. But for whatever other period you have, that's going to be unpaid. I mean, arguably that's fine. But if they simply say, no, you must return to work, and if you don't return to work, you're going to be terminated, then and if they terminate you for that reason, for needing to be on the medical leave, then that would be discriminatory. And so, I would say, Stephen, reach out to us. For situations like this, for Stephen, for C, when you have medical issues, when you have accommodation issues, things like that, a really key component when you contact us, just so we can give you the quickest help and the most accurate advice, is always sending your documents to us, your medical notes, any correspondence on the medical notes, or any leaves or accommodation requests and responses from your employer. Please send all those in. Like I said, there's a lot of analysis, these facts that will go into the ultimate advice you get, but we're more than happy to assist you. We've assisted thousands of people with really similar situations, and we're happy to continue to do so. So please do reach out. Okay, and so we have a question from Teresa on Facebook. Teresa asks, if I accept a remote work position, can my employer change this to have me go into the office in the future? Great question, Teresa. That's one that's actually been popping up very, very commonly nowadays. A few different permutations of this. Let me deal with yours first, and I'll run through some general propositions on this. And so, Teresa, if you accept a remote work position, a key component here is, was the position always intended to be remote? And if it was advertised as a remote position, and if you accept it on the basis that it would be a remote position, then generally your employer may not be able to require you to come in the office. Here's the caveat. The caveat would be if your employment contract has a clause in there which permits your employer to determine your location of work, right? And so sometimes what you'll have is I've seen job postings, people interviewed and hired into positions on a posting that it's a remote position at this time, but the actual employment contract has a clause in there. And what the clause says is the employer will be able to dictate whether or not the employee works from home or remotely, or the employee is permitted to work remotely, subject to the needs of the business, something along those lines. What that does is it gives the employer the right to recall you into the office. And if that's the case, if it has a clause like that, arguably, and again, there are facts that could take you outside of this general proposition. I'm just speaking in generals right now. Arguably, if you have a clause that looks like that, that's enforceable, your employer can choose the place that you work from. And if you refuse, they can terminate you, and that can be a cause termination, which would mean you may not be entitled to severance. Again, very specific. So I would say, if you're in a situation like that, send us a copy of your contract, and let's have a chat. Now, another kind of tangential situation that people have been dealing with is they were permitted remote work during the pandemic, and a lot of people became efficient at it. A lot of people became very comfortable with it, and that became what they refer to as their new norm. In those cases where the employer has allowed you to do that, it does not preclude them from recalling you back under the same situation. If your employment contract states something like you will work primarily or solely from, and then it has your office building address, or we will be working solely in office, your employer can recall you to the office. And if you refuse, it could be grounds for discipline or termination, up to and including termination. So that is a great question, Teresa. It is something to be very aware of, especially in this post COVID age. Remote positions, companies are seeing the benefit in them, but they are still, a lot of them are still wanting some employees to be in the office at certain times. And so we have another. So Teresa, hopefully that answers your question. We have another question here from Ronald. Ronald asks, my employer fired me when I gave my 2 weeks notice. They have not paid me for the 2 weeks and threatened to file a claim against me for damaged equipment if I tried to take legal action for unpaid wages. What can I do? They had offered me a promotion earlier on the same day. Well, Ronald, that seems like a very tumultuous day. And so, I definitely want more information as to, if you were offered a promotion, what led to a resignation and then a termination. I'm assuming this all happened, it seems to be on the same day. If you've resigned and given notice and the employer simply terminates you, there's a couple of things that we have to look at, whether or not there's a clause in your contract that deals with this. Arguably, they may be restricted to paying you for those 2 weeks. But depending on the timing and the reasoning for all this and how this all kind of played out, you may have a claim for greater severance. And again, this would be subject to your employment contract. I'd have to look at that. I think here, the part that I find, very problematic is that they're threatening to file a claim against you for damaged equipment if you tried to take action for unpaid wages. Well, I don't think I'd really have to say that a threat like that is not only inappropriate, but it's illegal. I would, you are owed wages that you have worked for. That's enshrined in the Employment Standards Act or the Employment Standards Code in Alberta and in each province. And so, Ronald, what I would say your first step should be is to contact, if you're in BC, the Employment Standards Branch. I mean, in any of the provinces, contact the Employment Standards Branch and file a complaint for unpaid wages. Really, if you didn't damage any equipment, and again, I don't know the specifics of this, but if you damaged equipment or not, arguably, unless you were malicious about it, they may not have a claim. If you maliciously damaged equipment, they may have a claim against you no matter what, whether or not you file a claim for unpaid wages or not. A key consideration here would be the fact that you only have 6 months to file an employment standards complaint. And if they want to come after you for damages and this is in BC, to equipment, they have up to 2 years. So they can simply wait until your unpaid wages claim, and this is me being pessimistic, but they could wait till your unpaid wages claim expires and then come after you for damages. But again, if there's no risk of you having done that maliciously or anything like that, or having damaged equipment, then I would probably recommend that you file an employment standards complaint. At least talk to the employment standards branch, and because you are owed those wages. I would also say contact us, because you got a bit of a tricky situation here with any employment contract you may have. Send that over to us. And reach out to one of us for a consultation. I'm more than happy to talk you through this, because it seems like a bit of a pickle, and hopefully we can give you some more tailored advice. Sorry, let me see. I've got another question. We've only got a minute or a bit so left here, so I'm just trying to power through some of these other questions to make sure I get them all. Teresa has a couple other. Okay, and so Teresa says, Teresa's question was talking about the accommodations. So according to the ADA Act, I'd like to know if reasonable accommodations are entitled to all that have a disability, either physical or religious. And so Teresa, disability, if you have a physical or mental disability, or if you have a religious exemption, that's protected under any human rights code in any of the provinces. There are reasonable accommodations that have to be made. And so your question seems to be, well, for example, I'm a night custodian and asked to be scheduled at a later time and was denied reasonable accommodations. So scheduling issues are always a bit tricky, Teresa. It really depends on, and this may be something we have to connect offline, because I see we only have a couple seconds left, but it really depends on why you need to be scheduled, what the disability or protected ground that you're claiming is. That's very important. And what the reasoning for being scheduled later for is, if this is new, or for example, if you took a position that you knew you couldn't meet with terms you couldn't meet, and then are claiming this after, that could change the calculus as well. So Teresa, I would say please reach out to us. Happy to have a chat with you. I do see we're out of time. Thank you everyone for the great interactions today, and please reach out to us if you have any questions. Tell your family, tell your friends. If anyone has any questions, we do free consultations. If you find this helpful, please like like this, subscribe, tell your family and friends, send them my links. I'm happy to speak to anyone at any time. Send them the website. And we hope to see you back here in a couple of weeks. Our next show, and myself, in a couple of weeks, our next show is going to be April 20th. That's this upcoming Thursday, 2 p.m. Eastern time, with my colleague, Jeremy Herman. He is in Ontario, but he's happy to answer any questions, and he'll direct you to any of the offices to answer your inquiries. All right, everyone. Thank you very much, and have a great day.